Let me begin by echoing Alice and the other speakers who have thanked John and Marco for organizing this very, very interesting colloquium. This has particular value to me. As I was mentioning to John earlier today, I've been thinking about the function of values in law for a long time. This collaboration with Alice has given me a chance to apply some of these ideas to a problem that is not my problem. I'm not a tax person, which of course means that if you ask any questions about tax, I will confidently assume that Alice will respond. But when Alice explained to me the problem that she's been working on for a long time, which is this problem of trying to figure out a theoretically satisfying account of income that actually matches what is done in United States income tax law, it soon became obvious that maybe some of the things I've been thinking about might be of some use in thinking about this problem. And the resulting collaboration, as Alice said earlier, has been a ton of fun. The challenge that we faced is of course, as Alice discussed before the break, how to understand the dissonance between how income is defined by Glenshaw Glass, all accessions to wealth clearly realized within the dominion of the taxpayer, the dissonance between that definition and the Internal Revenue Service's actual practices, which seem to frequently depart from the conventional understanding of Glenshaw Glass. So Alice mentioned a number of examples: the treatment of imputed income, tax treatment of government welfare benefits, the tax treatment of lunches that lawyers might pay for their clients, the tax treatment of caught baseballs, and the tax treatment, I might say, of caught fish. The question of why, when a fisherman catches fish, why that isn't income at the moment that the fish is caught. It is not treated as such, and yet, in some fairly direct way, it seems to fit the Glenshaw Glass definition of income for tax purposes. So, to try to understand this problem, the first theoretical framework we looked at was John Preble's idea of ectopia. We understood his ectopia as identifying a gap or a separation between the legal definition of income, in this case, from real-world events, and that when legal definitions are not connected sufficiently with real-world events that they speak to, this leads to doctrinal incoherence. John, of course, has argued for many years now that this is ectopia is characteristic of income tax law, and it's characteristic of income tax law with the definition of income as being perhaps its most problematic core. As John has said in one of his articles, and I'm quoting, "The ectopia of income tax law lies in the law's dependence on the existence of a concept of income. The problem is that the concept of income is not something that ultimately can be defined by law because it is not something that exists either as a physical fact or as an abstract thought." He goes on to suggest that defining income is, quote, conceptually a conceptual impossibility, close quote, because, quote, "At its borders, income is a fiction invented for the purposes of income tax legislation that does not have independent existence in the world of physical fact or abstract thought." It seemed to us very important to address this way of explaining the problem with the definition of income. First of all, because the ectopia concept challenges us to examine just how it is that legal definitions relate to the real world of our experience. It also seemed important because the idea of ectopia resonates with a sort of broader idea, which is that there's just something different about tax. And ectopia is perhaps the most coherent attempt to date to try to identify just what it is about tax that makes it different from other areas of the law. For us, examining ectopia pointed us toward an alternative framework, which I will get to in a moment, and that is the framework of aptness, which I put up on the screen simply because it's hard to get out of my mouth, so I wasn't sure you would know what I was saying. But let me just briefly, and this is really too brief, briefly summarize our critique of ectopia. We ultimately concluded that ectopia does not explain this dissonance between the definition of income, the legal definition of income, and the actual administrative practices that one observes in the United States. But as I said, it seemed critically important to examine this. And so a quick summary of our critique, which we explain at significantly greater length in the paper, is that ectopia depends on a controversial epistemology, namely that it is possible to compare the legal definition of income to the real world, to the real economic reality that underlies transactions that are subject to income tax consideration. We question whether there is any such access to the underlying real world that would allow us to compare the tax law definition. And the reason simply is that all we can know about the world is filtered through our concepts. The world does not present itself to us in an immediate way. It does not present itself to us independent of the way we conceptualize it, to the way we organize it, to the framework that we use to cope with it, to make sense of it. There is no access we have that allows us to put aside our concepts and our definitions and so forth. And so the real world that we encounter, that is, the world that we actually experience, is already conceptualized. It already comes in a form which is not fixed. It is largely conventional. We share views of the world with other people. It is contingent. Our views of the world change over time. It is provisional. We hold certain ways of organizing and understanding and conceptualizing the world that we hold provisionally, in the sense that we will revise them if new experiences suggest that our current ways of understanding the world are inadequate in some ways. And so, again, that led us to conclude that we just can't get to this kind of anchor in a fixed antecedent reality that the theory of ectopia seems to require. Now, again, this is just a very brief and very inadequate summary of an argument that we make at greater length and hopefully somewhat more persuasively in the paper. So that led us to a different framework, one that we call aptness. Aptness appealed to us because it does not depend on comparing the definition of income given to us by Glenshaw Glass to events in the real world, in the sense of a fixed antecedent reality. Rather, it depends on comparing the definition of income to the goals and values that constitute the field of income tax law. We take the position that every area of the law is constituted by a unique set of goals and values, that unlike the real world posited by ectopia, these do not reflect a fixed underlying reality. Rather, they represent the desires of human beings, and those desires are affected by convention, those desires are contingent, those desires are provisional. They can change, and they do change over time. But at any given moment in time, typically they are stable enough this set of values and goals are stable enough to give coherence to a field of law. Over time, they may change, and our understanding of the field may change, whether we're talking about tax or torts or criminal law or contracts or property. But at any given moment in time, there will, in most areas of the law, tend to be enough stability in our understanding of what the goals and values that constitute the field are to give the field coherence. Now, these goals and values, we argue, are generally multiple and heterogeneous. That is to say, in any given field of law, there will be multiple values that constitute the field, and they'll be heterogeneous in the sense that they can't be collapsed into one another or subsumed under some sort of broader or higher values. So in criminal law, there are the well-known values of retribution, utility, and autonomy. In the field of torts, at least in American tort law, we have concerns with fault, causation, compensation. Again, these are not fixed. What they are can change, and their relative importance in various contexts can also change. What we want to ask is whether the definition of income, the Glenshaw-Glass definition of income, is apt. So what does it mean for a definition to be apt? Well, simply that the definition reflects the relevant set of goals and values. For a definition in torts to be apt, it must reflect the values and goals that constitute the field of torts, and so on. If it does, if a definition does reflect the goals and values that constitute the field, then it will generate predominantly easy, which is to say non-controversial applications. If it reflects what we take to be the goals and values of the field, then we will understand why it is generating the particular results in the particular case that it is generally. I mean, there will always be difficult, controversial applications for reasons that have been suggested in a variety of papers today. But generally speaking, apt definitions will generate predominantly easy, non-controversial applications. So we can define aptness or an apt definition functionally in that way. What it means for a definition to be apt is that it generates predominantly easy applications. Now, tax is a field of public law rather than private law. In public law, governmental institutions monopolize the enforcement of the law. By contrast, enforcement of private law, torts, contracts, for example, is primarily in the hands of individuals. I mean, most questions of torts and contracts are actually resolved, addressed privately by people every day. The government is the enforcer of last resort. If people can't resolve their disputes in private law areas, then they may bring their dispute to a court in litigation, or in certain cases they may go to legislatures and seek legislative change in the field. But the government is the enforcer of last resort. In public law, by contrast, the government is always the enforcer. So the aptness of a definition is especially important in public law. If the government is always the enforcer of the law in public law, then it is important that the governmental agency charged with the enforcement be able to apply the definition easily and without excessive controversy. And because to reduce controversy in public law, administration is important. That is to say, the government is enforcing the law, so it is the question of whether its enforcement is controversial or not will depend in part on whether the government is administering the law in a way that is recognized as non-controversial. And so in the context of public law, aptness of a definition requires that the definition be administrable, one that the government can easily and non-controversially administered. So the question that we come down to is whether the Glenshaw-Glass definition of income is apt in the sense that I've just described. So to go back to the beginning, we have to ask, what are the goals and values of tax law? We know that there are economic values, efficiency, equity, both horizontal equity and vertical equity. But are those all the values? Are all the values that constitute the field of income tax law economic values? One way of understanding this question that we're posing is to go back to the idea of ectopia. And we could think about ectopia in this way. Now, I hasten to add that we don't think that this is what John means by, or how John would understand ectopia. But we might think about it in this way, that that economic values are the exclusive set of values that are relevant to tax law. And so a definition should reflect those closely. And the problem occurs when a definition in tax law deviates or is inconsistent with economic values. We take the dominant scholarly view to be this, that the only relevant set of values that defines tax law are economic values. Now, this isn't necessarily explicitly said, but we believe this is the underlying premise of much of the tax scholarship, or much of the scholarship about tax law. But as Alice has suggested, many court cases, and certainly Internal Revenue Service practices, can be understood only by taking into account additional non-economic values, namely values that enhance administrability, again, which is so critically important in public law. So, for example, the requirement of realization advances administrability, although it is not itself an economic or reflective of economic values. And once again, if we think about the IRS's failure to tax imputed income, or lunches for clients, or government welfare benefits, or caught fish, or caught baseballs, we can only understand those as respecting values that aren't exclusively economic values. But now we have a problem. And the problem is that while it seems that the actual administration of tax law properly takes into account multiple heterogeneous economic and non-economic values, nevertheless, there currently exists no theoretically satisfying account of income to explain this, to encompass and identify all the relevant values, economic and non-economic alike. Again, the dominant interpretation of Glenshaw-Glass tends to focus exclusively on economic values. So why no alternative account? Why don't we have a theory of income that explains the range of values that seem to be actually in play when we get IRS decisions? One answer that we offer is that an attractive theory of income would require a widespread agreement about the goals and values of income tax law. In the United States, we suggest, there is no such widespread agreement about the goals and values of income tax law. There is no widespread agreement about what ought to be taxed. That is, there's no widespread agreement about what ought to be considered income. And I say ought to be, again, because the issue to us is one of values, not of an underlying fixed reality. There is not, as Alice suggested at the end of her comments before the break, there's not even a widespread agreement that there should be income taxation at all, because there is no widespread agreement about the existence and scope of a moral obligation to share individual wealth with the larger community, which we believe is a fundamental value that underlies modern systems of income taxation. Still, there isn't a system of income taxation in the United States. The income tax law has to be administered. So if tax professionals, scholars, and judges cannot come up with a workable theoretical account of income, it is left to the Internal Revenue Service and to the courts to interpret Glenshaw Glass ad hoc in a way that renders it administrable. That means taking into account both any relevant economic and any relevant non-economic values. And this, interestingly, has been successful. These ad hoc decisions about what should and should not be considered income have largely avoided significant widespread controversy. So to conclude, if tax were just about economics, aptness would be easy. It's not hard to fashion definitions and doctrines that reflect one value or one closely related family of values. But tax is not just about economics. Tax is like other areas of law. It reflects multiple heterogeneous values. Some of these are economic, others are not. And yet, we think that in an important sense, in this sense, John Preble is right. Tax is different from most other areas of the law. Not, we think, because of ectopia, but because the multiple values that inform the tax law are generally unexplored and unarticulated. And hence, there is no theoretically satisfying definition of income. Because in tax law, there is deep disagreement about what set of general values define the field, and more fundamentally because in tax law there is deep disagreement about whether the law ought to exist at all, at least in something like its current form. And so with that, we invite any questions or comments.
Thank you very much indeed. That's very, very thought-provoking. May I start? There are a number of interesting contrasts between the way in which you describe the